Good afternoon, everyone. Welcome to day 2 of the Thought Leaders for Fire event focused on the Middle East. My name is Colin Diss, and I'm a director in Grant Thornton's insolvency and asset recovery practice. My business focuses on using insolvency and third-party finance as a tool for asset recovery and enforcement. We have 2 great sessions for you today. Firstly, we have the panel discussing how to establish an effective recovery plan in the Middle East. Then we'll be opening the insolvency locker to see what asset recovery tools are available to creditors, claimants, and insolvency practitioners. Throughout today's session, we'll be sharing practical, commercial considerations and real-life case studies to give color and context to our discussions. When building an effective recovery plan, I think it's vital to build the right team of lawyers, accountants, investigators, insolvency practitioners, and funders, and for that team to perform in harmony. This can be likened to an orchestra, with each professional playing their own instrument in the asset recovery strategy. And when each professional plays their instrument in silo, they sound great. However, when each professional plays their instrument in harmony with the orchestra, a powerful and effective synergy is achieved and recoveries can be maximized. So I guess that makes me the conductor for today's orchestra of panelists. And on that note, I'd like to invite our musicians to introduce themselves. Jeremy.
Thank you, Colin, very much for the introduction. So my name is Hussein Hayari. I'm a partner and co-head of the international arbitration practice at the law firm Withers. I'm based in London, although a tremendous amount of my work relates to the Middle East, one way or the other, both on arbitration matters, but also on enforcement and third-party funding matters.
Brill, thank you. And Waleed?
Hi, everyone. Thank you, Colin, for this. My name is Waleed Azzam. I am a partner with Hadaf & Partners based in Dubai. We're a local law firm. I specialize in complex commercial and corporate arbitration and litigation, as well as deal with the issues of local and international asset tracing and recovery.
Brill. And Nicholas?
Thanks, Colin. Hi, everyone. My name is Nick Bortman. I'm a co-founder of a firm of investigators in London called Ratus. We're a specialist practice, really only doing litigation and arbitration work.
Brill. And then last but not least, Jeremy?
Hi, everyone. My name is Jeremy Bressman. I'm a lawyer at Colbert & Kim, where I'm based in the firm's Tel Aviv office. We are a global law firm devoted exclusively to handling disputes and investigations, with an emphasis on matters involving international fraud and misconduct. And my practice in particular involves an emphasis on global asset recovery and judgment and arbitration award enforcement.
That's fantastic. Thank you. So I think we'll kick off and we'll start with you, Nicholas. Intelligence is a key component in our asset recovery armory. How do you develop an intelligence gathering strategy in the Middle East?
Well, I don't think it'll surprise anyone listening to know that one of the biggest challenges of gathering information in the Middle East is the lack of transparency. And that is something that is, the main challenge for us, of course. And when you compare that to the EU or particularly the US, where, in some cases you can, put a name in a database and get reams of information out across the Middle East, it's a very different scenario. And on top of that, even where information is public, you get into all kinds of issues around how public record information is defined and whether it's actually accessible and under what circumstances. So it's challenging, which just means for us that we really have to split, we have to focus on, 3 key areas, which is to say, we have to get whatever we can out of the public domain and really mine it as deeply as possible. But we often very quickly have to turn to witnesses, people, anyone who's on the inside of whatever, the subject matter is who can help us. And then often looking back to legal process. So thinking about where, traditional investigative methodology might kick back to allow discovery or some other legal process to take place. So just touching on each of those in turn, I mean, if you think about even the public record, it's not uniform across the region. So you've got places like the DIFC, which is obviously more of a common law framework. There's quite a lot of information available. But then if you look at other places in the United Arab Emirates, like Jebel Ali Free Zone or Iraq Offshore Free Zone, those have confidentiality rules that are similar to, say, the BVI. And then you've got Saudi and Lebanon and other places which all have sort of different regimes where different things are available. So you really have to kind of know each market in turn. And then in terms of, even if we're going around interviewing people and getting information from insiders, there's a lot of talk in our sector about the confidential source network. But really out there, your average person isn't going to have the inside track on some, specific transaction. So we're constantly having to figure out who is actually involved in, whatever we're investigating and approach them directly. And there, while you often are successful, at the same time, you can run into all kinds of cultural challenges in terms of, sensitivities around asking questions or whether, I, as a kind of American based in London, approaching, say, an Arab in the Gulf or an Indian national or anyone else, that, they might sort of give me a different response than they would give to others. So we have to sort of navigate those cultural issues carefully. And I guess going back to the sort of legal process is the sort of third possibility for us. One of the challenges in the Gulf is that you don't have, by and large, discovery, at least not in a lot of the, the local civil jurisdictions. So, you have to be creative about how you use legal process and in some cases, sometimes parallel criminal proceedings, for example, can be a mechanism for extracting more information. But because of all those challenges, I mean, what we are often, just because a case is in the Middle East, doesn't mean that the answers are in the Middle East. So we're often looking further afield and looking in Europe, looking in the US, and whether that means asset tracing, so looking for assets that might be held in Europe or the US, or anywhere else for that matter, or thinking about, what discovery options are available. For example, I've got a case that I've been working on for the last few years, where most of it, the subject matter is in Iraq, but we've sought discovery through 1782 applications in the United States. And so, although one thinks about the Middle East as the focus of these investigations, we're really looking globally in most of the kind of complex matters that we deal with.
Brill, that's excellent. Nick, thank you very much. Jeremy, as Nick alluded to, the jurisdictional tools are a critical component to any asset recovery strategy. However, are there some less typical non-legal strategic tools you consider when developing an asset recovery strategy in the Middle East?
Yeah, thanks, Colin. I think this really sort of piggybacks off of what Nick was saying. So at Covery & Kim are often engaged to help enforce large, complex arbitration awards and judgments where the debtor's assets might be parked in multiple jurisdictions around the world, including often in the Middle East. And you're absolutely right, Colin, that regular judicial tools are often a piece of any enforcement effort, often a critical one in our view. An enforcement campaign will necessarily involve looking at the laws of target jurisdictions to see what powers are available in the local courts to seek either recovery of assets or discovery and aid of recovery. And I'm sure many of the practitioners on this Zoom are aware of a lot of those tools, such as, for example, Mareva orders in common law jurisdictions, or Nick alluded to 1782 discovery actions in the US to seek discovery. And by way of an aside, I as I mentioned before, I sit in Israel, and a lot of these tools are available in Israel as well. For example, Israeli courts have the power to issue orders like Mareva and Anton Pillar orders and the like, which could be useful in any asset recovery context. But the typical judicial tools are really just sort of one piece of the pie, one tool in the belt for any large scale enforcement campaign. We try to build our strategy, we try to build into our strategy various other tools and considerations. And the goal here is increasing pressure on the debtor or the debtor entity to satisfy the award. And it's of course important, and this I think you alluded to earlier, Colin, that the tools aren't employed on their own or in a haphazard manner, but rather are part of a cohesive enforcement strategy. And the key, as I mentioned, the key is to find points that will put pressure on the debtors or on the defendants that will increase the likelihood of a quick and effective resolution. So here are a few that we sort of think about in our matters and strategizing to try to play a role in the enforcement campaign. So one is something we like to call an offensive investigation. And by what we mean by this sort of can vary from case to case. Sometimes it is using the firm's expertise derived from years in law enforcement to identify misconduct or illicit trade, illicit behavior, and package that information for local prosecutors and regulators who can bring forward some sort of legal process or investigations against the bad actors. And sometimes it involves identifying relationships that the debtor has with third parties that can help exert pressure on the relationship to put pressure on the debtor. I think these tools are particularly useful against parties based in the Middle East, even if they're not always used in the Middle East itself, as Nick mentioned. This often ties to other tools we consider. One of which, for example, is working with investigators. So this involves engaging firms like yours, Colin, to help us undertake investigations like the ones just discussed, and experts like you and like Nick, who can help in evidence gathering and your strong contacts in particular regions or locations. For example, I've been using investigators quite effectively in one enforcement campaign recently, and we had a case where our debtor was missing for many years, and we just were not able to locate him. And through the use of an investigator and the various tools that he had, he was able to locate the debtor's he was able to locate the debtor after 3 or 4 years of not knowing exactly where he was. And I think one other point to mention, by way of example, is PR and other media-related tools. And I think these can have sort of legal and extra legal effects. So for example, when you're dealing with large public companies, the laws in certain jurisdictions require that based on public information releases, the company may need to make a formal disclosure to investors or regulators, which you can imagine they're loath to do. In other situations, a well-timed PR campaign can increase pressure on the debtor or even on a third party connected to the debtor. And that can be particularly effective when timed with actions in courts to seek judicial remedies. So these are just a few of the tools that we like to look at, but I think are highly relevant to these sorts of campaigns.
Real, that's fantastic, Jeremy. And Hussein, when seeking to enforce an arbitration award or a judgment in the Middle East, what are the risks and challenges that you see, and how do you go about mitigating those?
Yeah, so I think the importance here really is of timing and thinking this through at the point when you're drafting your contract, so that you're anticipating already whether you're going to choose arbitration versus litigation, for example, considering enforcement down the line, where you're going to have, if it's an arbitration, your seat, what institutional rules are going to apply. Are you dealing with a state or state entity? Do you need to address issues of waiver of immunity, for example? Where are assets? Where will you ultimately be enforcing? So those are the considerations that ultimately are going to become relevant when it comes to an enforcement situation. But it is not too early to think of it at that point when you're drafting the contract. In fact, it's quite often too late if you don't think of it then. And I can give 3 examples from practice of where these issues can become of great importance ultimately when you're enforcing, particularly in the Middle East. So one of the cases was for a European company investor in the Middle East, and it was a construction project, and it provided for arbitration in Benghazi. It didn't provide for any arbitration rules. And so that choice was made, notwithstanding that Libya is not a party to, for example, the New York Convention on the Recognition and Enforcement of Arbitral Awards, although many other states in the Middle East are parties to it. So that created some complexity, as everyone can imagine, because with the local Libyan party not participating in the arbitration, there was no arbitration institution that had been agreed to in the contract, as could have been done, which could step in and appoint their arbitrator in default. And there were no rules to govern the arbitration. So we had to go to the Libyan courts to get a default arbitrator appointment at a time when they were barely functional because of recent developments. And we had to run the arbitration under the Libyan civil procedure rules rather than having the benefit of a framework such as the DIFC, for example, which would have been far preferable in many ways. So we ultimately got the arbitrator appointed, the proceedings continued, and we managed to get a successful award. But I think it is a good example of why you really need to think about those sorts of issues in terms of seat and arbitration rules right at the outset of your contract, because you can save a lot of time and money if you do it that way. Another example is of the potential benefit of arbitration compared to litigation, including because of conventions like the New York Convention and the ICSID Convention, which are allowing for enforcement internationally of arbitral awards, and many states in the Middle East are parties to those conventions, not all. So for example, I mentioned Libya is not a party to the New York Convention, nor is Iraq, for example, although it is a party to the ICSID Convention. But what's more important for this point is the advantage of arbitration, provided you're looking at the right jurisdictions compared to litigation. Because with litigation, you are more usually relying on a less comprehensive set of arrangements for recognizing other states' court judgments. And a good example of that is a case we were recently involved with, where we were looking to enforce a UK court judgment granted in favor of the wife of an individual, and on the dissolution of their marriage, and essentially looking to enforce against a yacht which was in the UAE, and in particular there was a very large award in favor of the lady who had received that judgment. So I think it was 350 million plus also the art collection. And this yacht was initially subject to a freezing injunction by the DIFC. And initially the onshore UAE courts provided for that on a preliminary basis as well. Ultimately, however, when this was challenged before first the UAE Court of Appeal and then the UAE Court of Cassation, they found that the UK court judgment was unenforceable as being contrary to Sharia. And so that is a situation where you're having to rely on essentially a quite wide degree of discretion as to whether an English court judgment of that nature would be enforced. In this case, it wasn't. Query whether the outcome would have been different had this been a commercial arbitration award, for example, where there is a very strong policy of upholding commercial arbitrations in the UAE and more generally in a number of other jurisdictions in the Middle East. Not always and still subject to public policy, but a sounder basis usually for enforcement. And that's been our experience recently with having a challenge to uphold a arbitration award before the UAE Court of Cassation for a Samsung entity, which was successful. So that's my second example of why this needs to be thought through in advance. The third one is where I say one should consider the seat, and that's important. It was a case I did for a Turkish construction company several years back, where the counterparty was a Jordanian state-owned entity. It was a construction contract for building a dam in Jordan, and the arbitration was seated in Amman in Jordan. And so although the construction company won the ICC commercial arbitration, there was subsequently a challenge to the award in the courts of the seat in Jordan, and the award was set aside. Not only that, but the underlying arbitration agreement was retroactively annulled by the Jordanian courts in favor of the Jordanian entity. So what we did at that stage is we brought a World Bank and ICSID arbitration on behalf of the Turkish investor Ata. This is a public decision. And so you can even find it publicly. And basically we said that the state of Jordan acted unfairly through the actions of its courts, retroactively annulling the arbitration agreement as well as award, and we got a successful award in our favor. So this is again just a sort of word of warning in a way of thinking very carefully about where you choose to have your seat. And I think it probably also dovetails quite nicely with the investment treaty protection framework and considering whether that can be useful for the purposes of ultimately enforcement as well.
Brilliant. Thank you, Hussein. And Walid, finally, in relation to this, when establishing a strategy for asset recovery in the Middle East, how do you go about building the most effective team?
Well, that's a good question, Colin. I mean, one of the first things you have to consider when dealing with asset tracing in the Middle East is, first of all, everybody knows that, it's the speed that counts, at any time that you are trying to figure out where the money went, you need to act as fast as possible. And I think Jeremy was saying, chasing that in the US to try and get access, to where, the dollar account transfers are gone. And when you're trying to build a team to do that, you have to figure out what are the jurisdictions or who do you need to find out, where's the money. So if it's a local issue, who can help you on the local scene, to assist in investigating what possible assets that, either the target or the shareholders or the directors may have, so that, the worst thing you would want to have is going ahead and proceeding with the litigation that takes a couple of years or more, and then in the end figuring out that you have no assets or you have no plan on how you're going to enforce the judgment. And we've had so many judgments that just do not have any teeth to them, because in the end you're helpless, you can't help your client to get the money they're entitled. So when you're looking at the team, do you want somebody that can help you locally or internationally? You look at that type of firm. Do you need investigators? Do you need somebody with forensic accounting experience? And there are a lot of good players out there. You just have to see who do you have and what relations do you have with them that you can get the quick action you want. If the money is being diverted from here and going to another jurisdiction, or it's coming here, you want to be able to contact these people and very quickly be able to at least figure out where you're going to go with this. Because initially what you want to try to do is just apply some kind of freezing order or attachment to try and stop that. And this brings us, to a second step in this is you have two routes that you can follow in this, which basically one of them is the civil route, which basically you try and proceed and seeking your own freezing order to stop the money movement, or using mutual legal assistance, and MLAs as they call them, and try to see if you can get the authorities to be involved and help you, whether from abroad or from here, to chase this money and freeze it. And from our experience, following the diplomatic route, sometimes it's really good and it will get you the necessary information and the depth of involvement that you would need. But sometimes the speed of doing that between any countries it is an issue, because it takes longer for the countries to send something to the other. Then they look at other issues, which reciprocity, politics, that can actually delay your action. So sometimes the best approach that we get is to use a combination of, a civil action that you can use to freeze some of the funds or target them, while at the same time using execution or the criminal system to assist you in pursuing that. One of the most interesting things that we have here in the UAE has been, I won't say the signing of the treaty, but it's more of the activation of the treaty with India. It's just because the fact that there's so much business between here and India, and so many, individuals that operate here that have, ties in India and the other way around. And until a while, like at the beginning of this year, there was an existing treaty, but the reciprocity was not, officially recognized until India, signed the necessary, law to make that reciprocity active. And with that, it actually triggered like a lot of claims, from the banks here who wanted to pursue guarantors, who wanted to pursue, companies, directors or shareholders who kind of left the UAE and went to India. And they were actually beyond reach because the system there would have been too cumbersome to recognize, a judgment, without clear reciprocity. And the other way around, we're aware we're being contacted by a number of Indian banks who are actually pursuing certain funds and certain individuals that got diverted to the UAE and other jurisdictions through the UAE. And before that, it was quite complicated because while latest amendment of the civil procedure have made it much easier to implement a foreign judgment in the UAE or a foreign award, the fact that, the UAE is a signatory to the New York Convention makes the implementation of arbitration award very straightforward. Within like maybe a week, you can get an ex parte decision to implement your award. The same is not similar in judgments. And Hussein's example is quite famous in this jurisdiction, for implementing a UK judgment and having to look at the issues of reciprocity, having to look at the issues of public order. So you have more hoops to jump through when you're enforcing a judgment. So once you have a treaty, it makes life much easier. And when you're looking at those things, you gotta creatively think about it. We've had an example where there was a fraud committed by a individual using a UAE company, a free zone, the Jebel Ali company, where they've managed to defraud, a major company out of like significant funds. And those funds got diverted everywhere. And those individuals left the UAE. And by the time this was discovered and action was the time bar for criminal action has passed. The only thing that left was to conduct, an arbitration in the UK to try and make a claim. But knowing that, the company has nothing, it's a shell company. So the target was always, how do you pursue the directors and shareholders? So what had to be done was you initiate an action, which you get an award in the UK. You come to Dubai to recognize that award through the Dubai courts. Then we've taken that award from the Dubai courts, and of course you can't enforce anything against the company because it has no assets, and you got a delegation letter and moved that award towards the DIFC, which is a common law system. You went into the DIFC and you made inquiries based on that judgment or recognized award with a branch of a bank here, for a European branch that had actually some of the money had passed through it. And behind those inquiries and getting those information, managed to release information from the European bank, the main bank there, because they were under obligation to provide the DIFC court with that kind of disclosure under a court order. And it gives you the access that you needed, which basically how some of those funds were diverted directly to the directors of the company. And now you've taken that actually, and you're taking this information and you're pursuing this in another European company, but now you've actually switched and you're switching your action against the directors and shareholders personally for taking the funds that, and this has taken years, but it was always from the beginning, we've used the necessary investigators to help us figure out where are the shareholders, where are the directors. We've done actions in the US to figure out where most of the money seemed to have gone. And following that, we started doing this, knowing that in order to get to the source, which is the person who has the money, you'd had to actually jump through all these steps to try and get it. And now we're actually at the last step, which now we're pursuing the individuals in their personal capacity for the funds they've taken after, I would say, nearly 6-7 years, action. So it's getting, the information that you have from the beginning and laying the plan is what gets you through this. And it's always if you draw the strategy from the beginning, it helps, to achieve a plan that you follow for years to go.
Brilliant, brilliant. Thank you very much for those thorough answers to those questions. I suppose what screams through to me is there are, a treasure trove of options and tools that are available to us. And if we can build and establish that team is going to require financing to execute our chosen strategy. And Jeremy, how can asset recovery practitioners utilize third-party capital to develop and enhance and execute the enforcement strategies that we would like to commit to?
Yeah, that's definitely right, Colin. As I'm sure you and everyone else listening is aware, third-party litigation financing has grown tremendously in this area in recent years. And I have no doubt it'll grow further as attorneys and practitioners become increasingly aware of its availability. The biggest reason that parties seek third-party funding to support an enforcement campaign is probably obvious, which is that recovering your lost money can be expensive. Defendants are often well-resourced and have had the time and money to structure their assets to avoid a party's enforcement efforts. So utilizing a third-party funder to cover legal fees provides the client with flexibility on upfront legal litigation costs, meaning that good claims can be realized without the client exposing themselves or their organization to unnecessary risk or limiting their liquidity for other projects and expenditures. This arrangement also benefits law firms because rather than take on all the risk of recovery itself through a contingency payment arrangement, the risk on recovery for their fees and expenses could be shifted to or split with the funder. In other words, in my opinion, I think litigation financing allows many more cases to be prosecuted than there might be without access to this capital. Besides the obvious monetary component, though, I think there are other good reasons to look to litigation funders or to seek out funding. So one is that funders often have additional expertise that they can add to the mix of information that we all consider in our strategic thinking about cases. So like our firm, funders come across and have to think about deploying capital in support of a vast number of cases. So they've been through these campaigns before and have insights that can help attorneys and others in their cases. They're not really just funds deploying capital, but they're teams of experienced professionals who know these issues. And I think a second reason is that although funding arrangements are often kept quiet, I think the perception of a party being backed by a funder can create some pressure on even a well-capitalized defendant by removing the perceived advantage of engaging in delaying tactics to increase the cost pressures on the claimant. Early settlement can also be encouraged by the fact that a third party, having conducted his own due diligence, is prepared to invest in the claim.
Real. Thanks, Jeremy. And Nicholas, how do you feel the financing impacts on your ability as an investigator to deploy your intelligence gathering toolkit?
Yeah, well, I mean, no surprise. Litigating is expensive, as we all know, for all kinds of reasons, and the information gathering aspect of it is can be just as resource intensive as any other part. And I think in terms of the financing, what it really enables a claimant to do is to think globally and work globally. So in terms of investigative work, be gathering information in many different jurisdictions simultaneously, as opposed to having to focus on one or two jurisdictions only. It also, allows you to kind of manage the reality of investigative work, which is that we're constantly going down dark alleys, and you don't always know what you're going to find. And sometimes it's a sort of silver bullet, and sometimes it's absolutely nothing. So you have to be prepared to spend some money, which isn't going to always kind of deliver the evidence you need, and that's just part of the process. And then, as I sort of touched on before, where it enables, obviously, thinking about ancillary action. So whether that's a discovery process in the U.S. or whether it's enabling some other sort of counterclaim or some other counter action or action to as a pressure tactic, and also thinking about other pressure tactics like communication, sort of PR campaigns and that kind of thing. So on the one hand, it's definitely it's essential having that kind of resourcing for I think to really be able to push these things as far as you can go, because the reality is that if you're in an enforcement situation where a respondent isn't willing to settle amicably, going all the way down the enforcement route is really difficult. And the example that's come up a couple of times that Hussein mentioned with the yacht in Dubai, I mean, that's a classic example where, here is an asset worth ostensibly hundreds of millions of dollars sitting in the water with a favorable judgment, but you can't do it. And, or not to say you can't, it's ongoing, but it's fraught. And at the same time, some of the structures that the asset protection structures that are put into place, whether it's, through offshore ownership or nominees, all of that stuff, it's not actually that expensive to do if a respondent has just put a bit of forethought into it. So, from an investigative standpoint, we definitely have to be able to work against those things and unpick those things and have the resources to do that. And, in the more sort of, the dirtier, more hard fought litigation, sometimes we find ourselves where the other side, if they're well financed, have hired, investigators as well, and not always to gather evidence, but sometimes just to try and thwart, the work we're doing. Just by way of one example, this is years ago, but I was leading an internal investigation for a U.S. metals company that had been essentially accused by its counterparty in the Middle East of corruption, and that had kicked off a sort of parallel U.S. government investigation under the FCPA. And in the context of this, I was approached by a small investigative outfit in the Middle East who basically said, I understand you're working on this. We've got some evidence that we think will be valuable to you. Would you like to meet and discuss it? And it's not uncommon that happens. And so, we had a couple meetings. They were sort of flighty. It didn't go anywhere. And then a few weeks later, I get a call from the client, and it turned out that one of those investigators had submitted an affidavit to the U.S. government, essentially alleging that I had been going around trying to buy evidence off of the other side, effectively, which it was just a honey trap, and it was a tactic. But we were able to sort of dismiss it very quickly. But it goes to show you the lengths that people will go to in hard fought cases.
Fascinating. Hussein, how is enforcement funding perceived and utilized by your clients?
Yeah, it's an interesting question, because funders, like, kind of commercial counterparties generally, usually think very hard about enforcement right at the beginning before they go through the process of funding. I mean, from my experience, some funders have kind of evolved out of essentially funding for enforcement purposes and have sort of moved upstream, if I can put it that way. And some have started out as funding litigation and therefore necessarily sort of moved downstream in the sense of also funding enforcement. So we've had experience of funders that have brought in other funders to co-fund on the enforcement side, sometimes by way of an additional agreement, additional framework. And yeah, we've had situations where funders have been very happy and keen to fund the whole process start to finish. I mean, I would echo what Nicholas says in terms of your counterparty. It's definitely an important consideration. Do you have a state or a state entity that ultimately you could be enforcing against, or is it a multinational or a high net worth individual where at least, you know, the insolvency risk and so on can be a relevant factor? Or are you dealing with a, you know, sort of single purpose vehicle in an offshore territory where, you know, assets may not be there for very much longer? So it's not just a question of, do you have a good claim, big claim, strong merits, good jurisdiction, admissibility, you know, straightforward or at least feasible, all those things. But of course, ultimately, the award has got to be enforced for it to be worth something. So, I mean, funders are very commercial and practical about that. Even if, as I say, they can tend to come from slightly different angles and risk appetites when it comes to enforcement. The other thing I'd just say is in the Middle East, I mean, we are seeing some interest in funding. We have got a client in the region as well, which is funded on a matter, and we've got other matters which are funded, but you know, from non-Middle Eastern clients, but the matter relates to the region, and there's a funding framework. So I think it's partly around the diffusion of awareness and education in a way about the existence of third-party funding. So I mean, the Middle East is not quite as I think probably it's fair to say familiar in general terms with the funding framework. It's not utilized quite as often as some other parts of the world, but I think that is starting to change, and we're seeing some practice developments around that as well. So the DIFC recently issued, I say recently, but in 2017, practice direction number 2 to do with third-party funding, including requirement of disclosure of the existence of funding and the possibility of third-party costs orders being basically you know, issued against funders in that framework. So there are a number of initiatives, developments around third-party funding, which is not heavily regulated, as many will know. And you know, generally there's either a self-regulating or relatively light regulatory framework, but these kinds of practice developments are you know, gaining traction in the Middle East as well as elsewhere.
Bro, and you mentioned sort of educational piece and an awareness piece there, and Walid, how are you seeing it on the ground in Dubai in relation to enforcement finance and that educational piece that Hussein alluded to?
Yeah, I mean, Hussein said a very important thing, which basically, yeah, with the exception of the DIFC, you know, I mean, just to be clear, you know, I mean, the UAE has a bunch of systems that are operating together. You know, I mean, you have 7 Emirates, some of them have their specific court system. Dubai has the DIFC, which is a common law system. It has the local court system, the Dubai courts. Abu Dhabi has Abu Dhabi Global Market Court, which is a common law system again, and they have the Abu Dhabi system. Then we have a federal system that governs some of the other Emirates. So the interaction of that is quite interesting. But other than the DIFC, I'm not aware. I mean, all the other, I don't think ADGM has passed anything on it, but I know for a fact the local courts do not deal with the issue of funding or regulate it. There are no specific laws on that. And this remains, you know, I mean, a contractual arrangement that you have, you know, with the client and the funder. But if you look at it from a global view, I can tell you that in the past 5 years or maybe even more, I mean, litigation funding, third-party litigation funding has been gaining some traction in that clients are starting to recognize that you can do that. But unfortunately, the culture is still not there. Basically, the clients would love to have funding for claims that they think are bad claims. And they don't understand why they would need to have, you know, I mean, funding for the good claims. They say, why would I need you to fund me for a good claim that I know, you know, I mean, I'm going to recover in the end. So they'd want to bargain down, you know, I mean, the benefit of that. And it's only recently, you know, I mean, I think with a lot of assistance from lawyers who are actually explaining that to their clients, or the funder themselves are doing a lot of effort going around just to educate people more than just get the business, to try and explain to them, look, you can manage your cash flow by doing your funding. You can look, your balance sheet will look better. We still take part of the risk, but it has to make sense to us as a business, like to be able to fund you, And some of the bigger companies and banks now are starting to look at the merits of that. It's like, look, maybe our balance sheet will look fine if we're able to do that. But again, I mean, I don't think we're there yet. I think Hussein is right, is that we're at this step where it's starting, like people are dabbling with it, like, and trying to find out what's the best approach or what's the benefit of that, but they're still not at the point of saying like, oh, like this is a good point, like, I mean, on that. And I mean, it's interesting because I think it benefits the client and it benefits also the lawyers, like by trying to explain. So many times we get clients that come to us and explain, like, I have a good claim, but I'm not able to pursue that. Can you do it on a success fee? And sometimes we're not able to do that, but we're saying, look, we cannot accept this risk, but how about we introduce you to one or two third-party funders that actually may be able to explain that. And just I stand corrected. I saw a note that came up and somebody said that ADGM does have regulation for that. So I wasn't aware of that, but I mean, that's coming from the common law system, which recognizes the funding more than just the local court system.
That's fantastic. I think we'll wrap up the first panel session there. I've personally got a few questions to put back to the panel, but we'll save those until the end of the second session. So if I can ask the members of the first panel to mute themselves and turn their videos off, and then we can welcome our second panel, which will be, we have James, Mark, DK, and Tina. Welcome all. Our second session is going to give us a practical exploration around the current trends in solvency legislation and possible tools available to claimants, creditors, and insolvency practitioners with a nexus in or a nexus to the Middle East. But firstly, let's ask the panelists to introduce themselves. So if we can start with James, that would be great.
Hi, Colin. James Fox. I head up the dispute resolution team at DWF in the Middle East.
Brilliant. And Mark?
Mark Beer. I spent 27 years or so in the Middle East, and part of that was in developing the DIFC courts and helping to run a few of the insolvency cases that ran through the courts there. And that led up to the creation of the Dubai World Tribunal, which was described by the chairman of INSOL as the leading restructuring regime in the world. And I'm now back in the UK acting as a non-exec to a number of companies that are going through a challenging moment.
And Tina?
Hi, Colin. Tina Iscarian from KPH. I will leave it to DK to introduce the firm. But I'm a lawyer here. I practice in insolvency and commercial dispute resolution with a focus on insolvency law and asset recovery.
Brilliant, thank you. And DK, over to you then.
Yeah, hi.
Sorry, DK, I think you've put yourself onto mute. I mean,
Sorry, I think you missed all of that. My apologies. I was saying I'm DK Singh here. I'm with KBH Kanun. We are a specialist DIFC-based practice. And I was mentioning it's good to see Mark here, who has been in the DIFC, and we've been sort of engaged with him for a long time. Our practice is largely based on financial services, insolvency, employment and corporate commercial matters. We largely focus on the DIFC court, but we also do arbitrations, particularly in the DIFC LCI and elsewhere. So that's essentially our key practice, and that's all for the time being.
Excellent, thank you all. And just to help set the scene for the session, I'm going to ask each of you the same question, which is, what sorts of asset recovery cases are you seeing at the moment? What sorts of cases do you expect to see emerging in your jurisdictions? And I'll start with you, James.
Yeah, so I think that many of the cases that we're seeing at the moment had their genesis actually quite a few years ago. In some cases, many years ago. Typically, we're seeing quite a few non-performing loans. And these are loans that have already gone through remedial action with the banks, where they've effectively tried to recover the situation. It hasn't worked. And now we're moving on to more aggressive recovery strategies. I think that going forward, cases are definitely going to be impacted by COVID. I suppose I think that there's probably going to fall down probably two rough lines. The first is well-run businesses or moderately well-run businesses that essentially their entire business case has been interrupted by COVID, and essentially they have fallen back, unable to service the loans that they've got. The second is the fraudsters. It's the companies that effectively are not well run, not doing what they should be doing, but until now have been effectively been able to keep the plates spinning. And when you hit an event such as COVID, which has such a significant impact, your ability to keep the money flowing, to keep robbing from Peter to pay Paul, all of a sudden stops, and you get caught out. And to my mind, the first one, it's probably going to take a little bit of time for those to flow through. But also to my mind, they should have two different strategies. So, Colin, as you well know, the best means of securing money from it's much easier to secure money from a operational entity. So for the first category, i.e. the well-run business that is just having difficulty, to the extent it's possible, you want to keep it an operational business. The second category, however, that money is being dissipated, it's being moved, and you need to go after it as quickly and as aggressively as you possibly can.
Brilliant, that's fantastic. And then over to you, DK. What types of asset cases are emerging with your client base? And do you see any likely trends developing?
I think James has touched on some of those points already. I think by and large, we are seeing distressed positions by borrowers who are particularly borrowed through funds of financial institutions set abroad and who have extremely tight funding obligations captured in good financial documentation. So I think that remains the same. Then in addition to that, I would say there are enforcement issues arising out of awards, which is, I think, commented earlier by Jeremy, or something far more simpler to achieve. But I would say simpler with a little bit of a qualification. So I think the issue really is, if I move away from the trends, generally speaking, because the trends will are sort of an economic consequence of where companies are here today and how the financial markets are working globally. But I think what is probably more critical is when such disputes arise, whether it be for COVID or of any financial downturn, it is how do these sort of lenders and or judgment creditors look at their options if the entities who are at the other end of it are based in the UAE or generally in the GCC. So you could have you could be in possession of an arbitral award, or you could be having a judgment in your hands in relation to debt owned by companies in the UAE and GCC, or you might even have a protective order. And I think we all sort of recognize that in the context of the Akhmedova case, but also earlier we've seen a protective order given in another case, pursuant to an arbitral award. So let's say that's what is in your hand. The key is how do you take it forward? Because the client always has, I think, as most lawyers will say, unrealistic objectives or getting in the shortest possible time at the shortest possible cost to the maximum recovery. That's where the challenge lies. So in terms of addressing the challenge, of course, the UAE is quite unique because you have to start electing as to which route should I go to. If you are a financial institution based in common law jurisdiction, then you're trying to think, okay, DIFC is where things can happen because I understand what happens in the DIFC. So do I have an option to go there? And often, so international law firms driven by their clients are trying to consider options in the UAE, and they often get conflicting advice. Well, if the asset is located in the Dubai onshore, then you should not look at the DIFC court. But Mark had often argued, well, that's not a reason for not looking at the DIFC court, and I would agree with him. There are, since then, the law has evolved. There are certain categories of cases which DIFC courts may find difficult to deal with. But by and large, if you're coming from abroad, whether it's a judgment debt or whether it's an arbitral award or you're seeking protective orders, DIFC courts have been very responsive. So on that basis, what I would just bullet point the approach and how decision-making process usually might happen. So the first thing you would want to do is, where is the asset? Can I identify it? If the asset is located onshore, does it prevent a bar for me approaching the DIFC court? And if so, why? The second is, who does the asset belong to? What is the transparency of that? So one of the difficulties you will find amongst borrowers, if you leave aside the large government-owned companies, most of the companies are asset-light companies because they are trading enterprises. The others are family enterprises, which are more dense because of their corporate structure. So getting through that whale is one of the big challenges, and which is where, and I think, Colin, your team is probably helpful. So once you have that information and you know where the asset is, then it's really a question of analyzing, do I go to ADGM or do I go to DIFC or do I go directly to Dubai court? So do I need freezing orders in anticipation of potential dissipation of assets? So I think what good lawyers need to do is really get the investigators in place, if you are going through the DIFC, get local lawyers on board, have a thorough analysis, because one of the key aspects of enforcement is that is their last step. And what clients are really not prepared to do is prepare themselves for 3 different alternative strategies. So you're most likely to get one shot at it. If you don't get there, then the client is not going to be very impressed with how you're going to look at it. So that really, in my mind, is what is going to develop going ahead in terms of a coherent strategy of enforcing potentially asset recovery matters.
Interesting. And Mark, obviously DK's opened the floor perfectly there. So over to you.
Well, thank you very much. And DK, it's lovely to see you again looking so well. You look as if you're in a padded cell, which I can only put down to overwork.
Well, I can say we are definitely overworked out here.
Well, you deserve it.
I might want to add since you left.
The world's gone mad, right?
Indeed. And also, I think we've missed the management of the courts here in your absence.
Well, that's really good of you. No, thank you. And well, look, I want to pick up on Colin on how you started, which is, in order to do this well, it is an orchestra. It is having the right people working collaboratively together. But at the core of it all, the question that one has to ask, and in my experience of these large-scale restructurings, the question to ask is, who is the conductor? Because as DK alluded just now, sometimes people leave it to the lawyers. And God bless us all, we're not very good conductors. It's not what we're trained to do. And most of us can't add up. As the joke goes, there are 3 types of lawyers, ones that can add up and ones that can't. So choosing the conductor becomes critical. And I'll tell you why it's getting more and more critical. Two elements. The traditional approach to asset recovery is becoming less effective. And it's becoming less effective because of the use of technology. Assets no longer represent physical infrastructure. Assets can be registered through the kingdom of Asgardia, a server bank in space. Assets can be in form of crypto assets sitting on multiple servers around the world over which not a single court or arbitration center has jurisdiction. So it's getting harder and harder as assets become less and less tangible. 80% of the US stock market is intangible assets, right? It's now IP. And that's really hard to effectively get value out of. So the traditional approach of going and finding a car or a building or a bank account is going to be outdone by asset recovery teams that are really good at technology. And that's because data opens up a new opportunity. I was chatting to someone the other day, they were desperate to find some assets in the name of a debtor. And the debtor, unsurprisingly, was not on any social media, was not connected in any way to the world. But their son was. And their son took a picture flying a drone over a yacht in Nice. And it was because they'd accessed the son's Instagram account perfectly legitimately, because there are jurisdictions that allow you to do that. They were then able to identify the debtor, visit the debtor, secure the boat, and secure recovery. So what I loved earlier, the conversations that we had was about, we've got to get the right people in the orchestra and we've got to have the right conductor, because in a world which moves towards a technology base for asset recovery, the traditional approach is no longer going to be as effective. And the second point I'll make is it's getting harder. When the world was globalizing, which was between 1971 and 2012, it was getting easier and easier. Global institutions were connecting. The DIFC courts, as you know, was the most connected court in the world. ADGM has followed. Singapore has followed again. So everybody was connecting. It was getting easier. The New York Convention that was mentioned earlier was a good forum for enforcement of arbitral awards, but no longer. It's getting harder because the world's deglobalizing. Barriers, boundaries, and borders are going up. So whilst we've lived in an era where it has been relatively straightforward, despite the opacity that we spoke about, it has been relatively straightforward to start moving arbitral awards around the world, don't think that's going to continue. It's going to get harder and harder. And so if the trends are the move towards assets being intangible and attaching assets and executing over assets is going to be harder, the team, the orchestra, has to get better and better, and the conductor has to be better at doing it. And that's what I think is going to be the trend going forward. The teams that are focused on those areas, understanding intangible assets, understanding that it's going to be harder to use litigation and arbitration, there has to be other ways of doing it, will succeed over these teams that just keep throwing money at a traditional process, which, to be fair, has never really delivered, but is going to get harder and harder in the future.
Well, thanks for that insight, Mark. Obviously, I am biased, and as an insolvency practitioner that tends to find themselves at the heart of these matters, I'd like to put myself forward to be that conductor, if that's all right with you. And I suppose moving on to James, and on the basis that I am the conductor for asset recovery strategy, what does the DIFC, Dubai and Abu Dhabi offer me as that practitioner, as a platform to instigate a recovery strategy? What tools are available to me as an insolvency practitioner?
Yeah, so I can cover, I'll cover the onshore, and I think Tina's going to cover the DIFC, I believe. So essentially, there are two key federal onshore laws, and by onshore, I should clarify that means essentially the UAE, apart from certain financial free zones. So, for example, the DIFC or the ADGM. There's the bankruptcy law and there's the insolvency law. Both of them are relatively new. Bankruptcy law is 2016 law. Insolvency law is even more recent. It's a 2019 law. Bankruptcy law covers companies. Insolvency law covers individuals. So it's in most asset recovery cases, the insolvency law would be the provisions are very similar, but you would, in most cases, you'd be looking at the bankruptcy law. Under the bankruptcy law, there's two key types of proceedings. There's composition, which is a voluntary agreement between debtors and creditors. You can cram down if you get 2/3 approval. And there's the bankruptcy provision. And the bankruptcy law provides for, it can be applied for by either a debtor or a creditor. If you're a creditor, you have to have 100,000 dirhams owed to you, which is in the region of, say, $25,000. And you have to provide a 30-day warning. It was a key law that was brought in by the UAE. There was a lot of focus on it and getting it across the line. And from an asset recovery perspective, there's a few key provisions that are quite interesting. So one of them is that if a debtor can't meet 20% of its debts, the court can immediately compel the board or the managers to pay the debts to the company. So that takes into account effectively the example where you have a company that effectively has been stripping assets for a period of time. The other provision essentially is the court can look at the manner in which the board have been operating the company. So, for example, have they been taking ill-considered risks? Have there been transactions where the benefit isn't consistent with the assets? Have they been preferring some creditors? And again, they can go and they can compel the board or the managers to pay in those circumstances. They can also, court also has the ability to unwind a transaction where there's clearly no due obligation to make payment. So from an asset recovery position, the bankruptcy law is really interesting and really useful. A couple of things that are probably worth mentioning. It hasn't been, we refer to it as being relatively new, even though it's a 2016 law. I think the reason why people say it's still relatively new is because it's hasn't been utilized as much as I think that it would hope it would be. There's quite a few small bankruptcies, but the big bankruptcies, we're not seeing them kind of flowing through the system that much. The other interesting thing in the current market is there has been an announcement recently, very recently, that they're looking at the impact of COVID. They're looking at potential grace period of 12 months in circumstances where you have a bankruptcy. And this is obviously in recognition of the very unusual circumstances that we're in at the moment, and trying to give these companies a lifeline in circumstances where actually you might see a flood of these cases. So that broadly covers the onshore bankruptcy provisions with actually a focus on, okay, if you're going against assets, what is it that you can do? What are the provisions that are particularly helpful to you?
And DK, I think you're going to pick up on the offshore region of DIFC.
That's correct. Thank you, Colin. And I think there's obviously a significant difference between how the DIFC insolvency law works and how the onshore law is developing. And I think they've recently also introduced, as James would probably know, a law in relation to personal bankruptcy, which I think is intended to assist individuals who had difficulties and were potentially subject to criminal procedures. But I'll leave that aside. And under the DIFC insolvency provision, I mean, we also had a new law which was passed just last year, 2019. It is sort of refined and added new provisions, bringing it more in line with, I would say, largely UK insolvency law, but also incorporating other international best practices. I'm not going to delve too long on that. I'll just simply sort of give you what are the changes. I'm sure everybody knows that there have been changes in relation to antecedent transactions. So essentially bringing to account the management of the company if they've done transactions which unfairly prejudice creditors in relation to a potential insolvency that may be looming. They've also brought in, on the basis that it follows the UNCITRAL model on a cross-border insolvency, they've streamlined that, and that is something which Tina will touch upon. They've additionally introduced a rehabilitation regime, which essentially means that rather than go for the eventual option of putting the business out of kilt altogether, can we rescue it? And on the same basis, appointing independent administrators. These changes are obviously new. How they pan out will be interesting to see. I'm just going to pick up on one point which James mentioned about insolvency regime not being used onshore on a realistic basis where we would see the developments in the jurisdiction, in the jurisprudence of it. There have been a few big insolvencies as compared to that in the DIFC, but effectively they were large insolvencies which emanated from elsewhere, particularly in relation to financial institutions. So Abraj is one good example where the liquidation commenced in Cayman Islands and then flowed through to the DIFC. And a few years before that, similarly, it was Espirito Santos Bank. And we were involved in both of them on some basis. So I think we did have big bankruptcy, but why don't we have big bankruptcies in the DIFC, generally speaking, is the question. And that is because I think most of the large financial institutions, the DIFC is essentially a financial products-driven business, financial product and services-driven business. And then in terms of other businesses which operate here, retail, hospitality, and potentially law firms or auditors or insurance companies, the bankruptcies have seen in the hospital. So we've had a fairly large number of restaurant, other entities who operate here outside of the financial services who went into liquidation. And usually the experience has been in relation to what is the position of the employees. And that's an interesting twist as to how the DIFC insolvency regime operates. The employees often go to the small claims tribunal. And we've had instances where a liquidator has been appointed and the small claim tribunal has completely sort of ignored his appointment and passed orders in relation to realization of assets by attaching the assets. So that obviously what has followed, therefore, is an approach to the CFI and trying to get that into place. And I think Tina has worked on a couple of other such matters, which hopefully will lead to some new practice direction in relation to how to synchronize the practice between the small claims tribunal and the CFI. But having said that, as far as the DIFC courts are concerned, and particularly in the context of court-appointed liquidation, I'll give you one example of a company called Orion, which was liquidated in 2010. It is still ongoing. It has gone through an entire gamut of liquidation procedures, including the liquidation partly being through court, partly being through members' voluntary liquidation in relation to entities sitting in the US. Subsequently, the liquidator approving claims against directors successfully, default judgments, securing orders in relation to realization of assets in Switzerland, again, something which Tina will talk about. So I would say the DIFC courts themselves have been, I would say, very open to giving orders which would essentially provide an equitable relief in situations where the insolvency regime is still developing. So overall, I would say the DIFC insolvency law and how the courts and how the company's registrar respond to such situations have been quite encouraging. And I'm hoping that that shall, in a sense, be followed in onshore, which is where the real businesses sit. And if that happens, I do think there is a real requirement of harmonizing potentially insolvency regimes within the DIFC and outside. But whether that will happen or not is a different matter altogether.
The concept of universalism in the GCC is an interesting one from my perspective. My personal preference would I'd love to see it, but we won't hold our breaths on that one. Mark, DK's alluded to some of the challenges in the Middle East. So obviously an evolving, fast-moving set of jurisdictions when it comes to insolvency. What challenges have you seen, and do you think insolvency can be deployed as a successful strategy?
Well, there is a part of me, a mischievous part of me, which would suggest that one of the reasons that people may not choose the DIFC route to restructure is that if it takes 10 years to do a relatively straightforward one like Orion, how long is it going to take to do a complicated one? Because as Waleed said, speed is very much of the essence, and creditors have a choice now. Creditors they may well be local institutions, but they're going to ask their insolvency practitioners, where will I get the highest return in the shortest time? And if we look across the options, it seems to me that there's the tried and tested Chapter 11 route, and it comes up in every conversation I have as an advisor to companies going through restructuring. So Chapter 11, it's tried, it's tested, it's relatively quick. You can pre-pack in 6 months. The judges know what they're doing, and the creditors are comfortable with it. Yes, it costs 3 times as much as it would if you went through the local system, but in the scheme of things, the costs are not outrageous. But why should we take a Middle Eastern dispute and run it through the courts of the US and then have the possibility of challenges later on? And that was the question that was first raised on December the 14th, 2009, with the Dubai World situation, particularly a situation driven out of real estate. And for the first time in the history of the Middle East, Dubai proved that it was able to handle a very large, and at the time it went into, about December 14th, there were over 1,000 subsidiaries of the group, but a very complicated, very difficult, very aggressive restructuring. And what's happened since then is we've actually got quite a good, in the UAE, we've actually got quite a good restructuring law onshore, UAE, right? We've got the development in DIFC, and we've got the developments in ADGM. And I ask myself, has the region's time come? And to my mind, it has. I think the choice by Alvarez and Marsal to use ADGM as the forum for restructuring for NMC, and if any of you have had the chance to see the hearing that took place, will demonstrate the capability of the region to handle very large and complicated restructurings. That is a good trend. It's a solid trend. It's a trend that DIFC is well able to follow. It's a trend that will lead us towards the ability for companies that are going through challenging times to maximize their situation. And so I'll finish on this, Colin. What does that mean for the onshore? Well, the onshore is always considered, but largely by government officials and by state-owned banks, it's discounted. Why do they discount it in favor of other routes? Largely for 2 reasons. One is it's totally untested. The second one is that when you run the finances on it, the recovery is both more volatile and lower than going through DIFC and ADGM. Part of that volatility is that although they've passed a pretty good law, and although they've got amazing advisors, many of whom are on this call, they haven't yet got round to teaching the judges. So you're putting into the hands of judges in the UAE an enormous amount of power but they haven't been taught how to use it. I think until that position changes, it's going to be difficult for institutions to rely on the law and the system that backs it. But that may not be such a bad thing in the short term, because ADGM and DIFC and equivalents are there to pick up the slack. So in summary, it's a very positive position. I think the region has proven itself that it can handle its own disputes. It costs a third to go through ADGM or DIFC than to go through Chapter 11. It's got brilliant advisors on its doorstep. And over time, we hope that the training percolates into the local court system where the federal law can be used for the onshore businesses.
Brilliant. Thanks for that, Mark. That's fantastic insight. Really appreciate that. Given all those positive aspects that Mark's just alluded to, James, what tools and techniques are available to insolvency practitioners operating with a Middle Eastern nexus?
Yeah, so I think my recommendation here would be always think big picture. Don't, just because you are looking at as an insolvency practitioner looking at the UAE doesn't mean that your focus should be necessarily only on the UAE. If there is a parent company that you can go after and effectively put into liquidation, then, which might be in Cayman, that might get you, even if it doesn't have assets, even if it's a shell company, that potentially gets you control of the UAE entity. It also potentially gets you access to information. So always think about, don't focus your thought process just because you're looking at a UAE issue. Doesn't necessarily mean that your solution should only be UAE focused. I think the other thing is, and this ties into the conversation about effectively how the bankruptcy law is relatively new, and I would agree with Mark, relatively untested, but that's actually, to my mind, to some extent, an advantage, because it's not that there were no provisions prior to the bankruptcy law coming into effect. It was just that there wasn't a law that was dedicated to bankruptcy. And that means that you have got provisions under the Commercial Companies Law, you have provisions under the Civil Code, all of which you can utilize without actually having to go through a bankruptcy procedure. So, for example, if there's a primary principle under the Civil Code that property of a debtor stands as security for the performance of their obligation. So what that means is, what you can't, it's essentially you are breaching that principle if you go and dissipate your assets in the knowledge that there are creditors that you owe money to. And that means that as a matter of, under the Civil Code, you can go directly after those assets. And for example, gifts, you can seek to unwind gifts for a period of 3 years. So there's underpinnings under the law. Likewise, under the Commercial Companies Law, you can, in circumstances where you have directors or managers that have been dissipating assets, that is a breach of the company's law. It leads to personal liability on those managers. Not only does it lead to personal liability, it can also lead to criminal liability on those managers and directors. So, to some extent, the fact that the bankruptcy law is so recent means that is actually an advantage, because there's actually other provisions, which means you don't have to go necessarily through this untested route, and you can go through an execution procedure whereby you can actually unwind transactions that happened as long as 3 years ago in order to secure assets.
Thanks for that, James. Obviously looking at an angle there of taking an overseas appointment and seeking to have that recognised in some way in the jurisdiction. Tina, do you have an equivalent example where you've looked to obtain recognition of a DIFC appointment out the jurisdiction to create similar leverage but in the opposite direction?
Yes, thank you, Colin. We have. The new DIFC law, as has been mentioned, brought with it the introduction of the UNCITRAL model law on cross-border insolvency, which allows foreign insolvency proceedings to be recognised here in the DIFC. But of course, as you've just noted, that begs the question, what about the other way around? Now, we've recently been involved in assisting with the recognition of a DIFC appointed liquidator in Switzerland. Now, in this particular case, the company's assets are held in a Swiss bank account, and the Swiss bank will only release the assets to the DIFC liquidator if his appointment is recognised by the Swiss court. Now, although Switzerland has not adopted the UNCITRAL model law on cross-border insolvency, recognition there is undertaken via the Swiss Private International Law Act of 2019, often referred to as SPILA. Prior to SPILA being amended, recognition of foreign insolvency proceedings in Switzerland was only available on the basis of reciprocity, making it very difficult to obtain recognition of foreign liquidators in Switzerland. However, all of that changed in 2019. The need for reciprocity was abolished, and the recognition of foreign insolvency proceedings now primarily centres on the liquidation being commenced by a sovereign order, which has all of the minimal effects of a typical bankruptcy. Now, one of the other useful amendments which was brought in with the amendment to SPILA is to permit the IP, for example, in this case, our DIFC IP, to request that no ancillary bankruptcy proceedings are opened in Switzerland, but that the IP is given permission to act in Switzerland and to repatriate assets located within Switzerland to another jurisdiction. That was ideal for us in this case because all we wanted to do was move the monies held in the Swiss bank account and have them transferred to the DIFC bank account without incurring all of the additional costs and expenses of having a full-blown parallel set of proceedings ongoing in Switzerland. However, the primary hurdle we faced, and this is really going to be the takeaway from this particular example, was the fact that the DIFC liquidation was a members' voluntary liquidation. Now, we decided to test the boundaries of the new law and see if this would effectively fly with the Swiss courts. But after a careful amount of deliberation by the Swiss courts, they concluded that the revisions to SPILA didn't extend to recognising a member's voluntary liquidation or private bankruptcies as they are known in Switzerland. And we were very politely asked to reconsider our application and present it in a different way. Therefore, we applied to the DIFC courts to have the liquidation converted into a court-supervised liquidation. That application was granted, and the matter has now been remitted back to the Swiss court for review and reconsideration. And we're waiting to hear if the liquidator's appointment and effectively the DIFC insolvency proceedings will now be recognised so that the money can be transferred from Switzerland back here to the DIFC. And so, as I mentioned a moment ago, the real key takeaway from this, when you're looking from a DIFC perspective to enforce liquidations in other jurisdictions, is to consider whether the liquidation will be deemed to be a foreign proceeding. Now, although a member's voluntary has all of the minimum effects of the liquidation, one of the sticking points with seeking recognition of a solvent liquidation is that it has the purpose of producing a return to its members and not its creditors, which can be quite difficult when it comes to recognition of foreign insolvency proceedings. As typically the purpose of recognition is for foreign proceedings is to assist with the recovery back to creditors. Now, this was a case in which the insolvency had been going on for 10 years. The company in this case can no longer be said to be solvent. And so the assistance of the Swiss courts was being properly requested. However, what we discovered was that unlike the flexibility that can be brought into play in common law jurisdictions, where perhaps the court there can consider the surrounding circumstances of the liquidation and even undertake an investigation to see whether or not this genuinely is a solvent liquidation. It may have started that way, but over the course of 10 years has evolved. And look at the structure and the overall makeup of the company group. And in this case, the parent company has always been under court supervised liquidation. So this wasn't a case where we were seeking to abuse the position or the powers of the Swiss courts in any way. We found that that simply wasn't possible before the Swiss courts, and we really had to follow the letter of the law right down to the very last full stop. So that's something that we would certainly recommend that everybody takes away when looking to have foreign proceedings recognised, particularly in Switzerland under the new law. And that just leads on to one very quick and final sort of interesting question, which is whether or not the DIFC court would have reached the same conclusion had it been, for example, a member's voluntary in Switzerland that was seeking to be recognised here in the DIFC. Now, the answer trial model law doesn't define insolvency. However, insofar as the DIFC courts will be guided by the interpretation in the English courts, there is a recent case from the beginning of this year, Sturgeon Central Asia, where the court there in England found that the answer trial model law is there to provide relief upon recognition of foreign proceedings that are concerned with debtors that either could not pay their debts or were struggling to pay their debts and seeking to reorganise. Therefore, a solvent winding up wasn't considered sufficient for the foreign proceedings to be recognised before the English courts. Now, I understand that case may be going to appeal. I don't know if that has been decided on appeal, but I'll end by saying this: simply watch this space to see if the DIFC courts will adopt the same approach, and whether it's only a creditors or a court supervised liquidation that will be recognised here under the answer trial rules.
Thanks, Tina. Seeing the time, looks like we're getting very close to the end, if not at the end. But there was just one question I wanted to ask to Mark, if we've got time, which was, to pick up on the point you made earlier, with legal hurdles becoming higher, the cost to deploy those legal strategies becoming more capital intense, litigation and jurisdictional risk at a high. Are there any non-legal strategies that we as insolvency practitioners should be considering when seeking to enforce with the Middle Eastern nexus?
Given the time, I will only echo and say I entirely agree with Jeremy's analysis earlier and the analysis of others, that many tools have to be analysed in the toolbox to determine the best possible outcome from a client point of view. Arbitration may be one, litigation may be one, PR may be one, reputation and association may be one. There are lots of different tools in the toolbox. The key is to get the right tools to do the job and then have a professional use those tools at the right time in the right place. It comes back to the beginning, Colin, the orchestra. Jeremy said it much better than I will, so I'll finish on that.
Brilliant. I'm just going to open it up to the floor to see if anyone has any questions for any of our panelists. I don't think we've had any questions through on the chat so far. One question that I didn't get to ask during the course of the panel was in relation to the impact that we think COVID has had and may have on deploying the strategies that we've discussed on the call today. So I don't know, potentially Jeremy, if you could pick up on that question and quickly outline, how you and Cobra and Kim have dealt with the current pandemic and how you think that might impact moving forward.
Sure, Colin. Yeah, I think it's been a little bit of a mixed bag. In general, it hasn't really impacted the demand for asset recovery services, and probably given the level of fraud and misconduct that I think we're all assuming has occurred and will still occur as a result of the pandemic, I expect the demand to increase. And I don't think it's really changed the way we sort of think through and strategize about the cases. I think there has been some impact on speed and the ability to sort of quickly collect evidence or get an application or a motion heard. There's some jurisdictions where there are moratoriums on certain forms of debt collection. There is, the inability to maybe be on the ground to go and collect evidence has, I think, slowed things down. And I think that's been problematic to some degree because it gives defendants and debtors more time to secrete their assets, structure their assets around enforcement mechanisms. That said, I think that the key here, and this is something that I think everyone here has sort of stressed, is that rapid enforcement relies on creative and effective practitioners, and it relies on the ability of courts and court procedures to remain efficient and third parties to sort of listen to and react to what practitioners are asking them to do, like freeze funds, freeze assets, et cetera, and those have by and large held up. So I think there's no question that at least early on there was a little bit of confusion and perhaps a little bit of a slowdown. I think as we sort of get further along in this pandemic, things have sort of figured themselves out, and I think that the strategies that we all want to put in place are coming to fruition.
I think if I can add to that, what I'm starting to see now is prioritization by court systems, and court systems are as important for arbitration as they are for litigation, right? Because at the end of the day, an award is only valuable if you can get a court to recognize it. And what's starting to happen around the world is prioritization over how they're going to deal with the post-COVID tsunami of backlog and cases. And what that means is that if, as Walid said, speed is of the essence, it seems to me that if you're going to be in a contentious restructuring, litigation and arbitration may not be as effective as they've been in the past decade. And that's not to say they're not an important part of the facility, but if I was a vulture creditor and I'd bought some debt and I wanted to maximize it, I can use the system to exert significant pressure on the creditor committee or on the insolvency practitioner to pay me out by leveraging the inefficiencies that are building in many court systems around the world due to the backlog. And that's why I think COVID does represent a time for the conductor to look very carefully at how they're going to deploy tools and what value those tools have in order to achieve the goal of the client. And it takes me back to my first point. I think that we have moved now into a different way of looking at restructuring and asset recovery. And the organizations and the people around this room who've embraced that will do very well. But those that haven't will find themselves in ever longer and more expensive battles to try and recover a diminishing pot of asset, which is likely over time to diminish, not only due to the costs of the restructuring, but also because it can find its way into a virtual world, which is almost impossible to trace.
Thank you, Mark. Does any of the panelists have anything to add to that before I draw to a close? Because I'm conscious that we are overrunning. Look, I will use that opportunity to close. I'll keep my remarks short and sweet because I can see the time. I think that the takeaway for me today is that there is going to be a continued trend for the deployment of asset recovery, insolvency, restructuring, dispute resolution through the Middle East. But as Mark's alluded to, they have the tools, the skills, the resource, the expertise, and the experience to effectively work out those situations and issues. And as recovery experts and professionals, we need to ask ourselves, the same questions that Mark and others have alluded to. What is the goal that we're trying to achieve? Where are the assets? Where are the pressure points? Where are the stress points? What are the routes and tools to those assets, those pressure points and those stress points? And who do we need to develop the most effective strategy to exploit those routes? Where are we going to deploy the strategy? There's a multitude of jurisdictions and options in that respect. Who are we going to tell about the strategy? Do we want to tell anyone about the strategy? How are we going to finance the strategy? And how are we going to stress test the strategy to make sure that it is effective? And then when do we pull the trigger on that strategy? And these are all questions as asset recovery specialists and professionals that we need to be asking ourselves at this outset of any case to ensure that we develop and execute the most commercially pragmatic, creative, flexible, cost-effective solution for our clients. So I think this just leaves me to thank all of the panelists, to thank Thought Leaders 4 for setting this up, and to thank all of you for listening. And hope to see you all again very soon.